Hello, ladies and gentlemen. I am Professor Rakshit of the O.P. Jindal University. The module is Human Rights Complaint Procedure. The background is basically simple. On 18 June 2007, the United Nations Human Rights Council adopted Resolution 5.1 entitled Institution Building of the United Nations Human Rights Council, by which a new complaint procedure was established, basically to address consistent patterns of gross and reliably attested violations of all human rights and all fundamental freedoms occurring in any part of the world and under any circumstances. The complaint procedure addressing communications submitted by individuals, groups, or in other words, bodies such as non-governmental organizations that claim to be victims of human rights violations or that have direct, reliable knowledge of such violations. The complaint procedure replaced the so-called 1503 procedure, which had been established in 1970. This was established by the UN Commission on Human Rights and maintained by the replacement body. The Human Rights Council, the 1503 procedure, allowed the Council to examine communications received from individuals and other private groups with the aim to address consistent patterns of gross and reliably attested violations of all human rights and all fundamental freedoms occurring in any part of the world and under any circumstances. Now, it is to be noted that even though this procedure allowed for individuals and non-governmental groups to file a complaint, no individual redress was possible under this procedure, nothing at all. Instead, the complaints aimed at identifying a consistent pattern of gross and reliably attested violations. When the Council received a communication under procedure 1503, it could adopt several responses. It could inter alia discontinue considering the situation when further consideration or action was not warranted, submit a request for additional information from the state concerned, appoint an independent expert to closely and very methodically monitor the situation and then report back to the Council. It also wanted to take the matter up under its public procedure or recommended it to the Office of the High Commissioner for Human Rights, that is OHCHR, to provide a technical cooperation, capacity building assistance or advisory services to the state concerned. In compliance with the mandate entrusted to it by the General Assembly, the Council decided on 30th June 2006 to establish the working group on the implementation of operative paragraph 6 of General Assembly resolutions. This resolution was resolution 60 of 251, decision 1/104 to formulate concrete recommendations on the issue of reviewing and when necessary improving and rationalizing all such mandates. Furthermore, it also talks about rationalizing mechanisms, functions and responsibilities of the former Commission on Human Rights, including the 1503 procedure. The working group held 3 formal open-ended sessions from 13th to 24th November 2006, 5 to 16th February 2007 and 10 to 27th April 2007. The segment on the complaint procedure was chaired by the permanent representative of Switzerland, who was appointed at that time by the President of the Council. His functions were basically to facilitate the consultations on this mechanism. The discussions in the working group and various rounds of informal consultations were conducted on the basis of an initial and subsequently revised framework. This framework was basically prepared for discussions which were in turn prepared by the facilitator. Following the last session of the working group, a final proposal, that is HRC 5/15, was submitted by the facilitator to the President, taking into account, to the greatest extent possible, the positions expressed during several months of consultations with a view to facilitating the drafting of the section on the complaint procedure of a final document on institution. Now, this institution building of the Council was adopted in June 2007. The ECOSOC resolution of 1503, that is XL 8 of 27 May 1970, as revised by resolution 2000/3 of 19 June 2000, served as a working basis for the new complaint procedure. The main features of the complaint procedure were as follows. The new procedure under resolution 5/1 maintains many of the features of the former 1503 procedure. For instance, it is confidential with a view to enhancing cooperation with the state concerned. However, the new complaint procedure has been improved where necessary to ensure that the procedure be impartial, objective, efficient, victim oriented and conducted in a timely manner. Pursuant to paragraph 94 resolution 5/1, the chairperson of the working group on communication, together with the Council Secretariat, undertakes an initial screening of communications based on the admissibility criteria set in paragraph 85 to 88 of resolution 5/1. Manifestly ill-founded and anonymous communications are screened out. Communications not rejected in initial screening are transmitted to the state and to the state concerned to obtain its views on the allegations of violations. Both the author of a communication and the state concerned are informed of the proceedings at each and every stage. Then they have the working groups. Now, there are 2 working groups, the working group on communications and the working group on situations. They are responsible respectively, for example, written communications and bringing consistent patterns of gross and reliably attested violations of human rights and fundamental freedoms to the attention of the Council. Now, B talks about criteria for a communication to be accepted for examination. A communication related to a violation of human rights and fundamental freedoms is admissible, provided that it is not manifestly politically motivated and its object is consistent with the Charter of the United Nations. The Universal Declaration of Human Rights and other applicable instruments in the field of human rights, law and other perspectives. It gives a factual description of the alleged violations, including the rights which are alleged to be violated. Its language is not abusive. However, such a communication may be considered if it meets the other criteria for admissibility after deletion of the abusive language. It is submitted by a person or a group of persons claiming to be the victims of violations of human rights and fundamental freedoms, or by any person or group of persons, including non-governmental organizations, acting in good faith in accordance with the principles of human rights, not resorting to politically motivated stands contrary to the provisions of the Charter of the United Nations, and claiming to have direct and reliable knowledge of the violations concerned. Nonetheless, reliably attested, communications shall not be admissible solely because the knowledge of the individual authors is second hand, and further provided that they are accompanied by cogent and clear evidence. It is not exclusively based on reports disseminated by mass media. It does not refer to a case that appears to reveal a consistent pattern of gross and reliably attested violations of human rights, which are already being dealt with in a manner by a special procedure, a treaty body, or other wing of the United Nations, or for the matter of fact, similar regional complaints procedure in the field of human rights. Domestic remedies have been exhausted unless it appears that such remedies would be ineffective or unreasonably prolonged. Then, having said that, one should also take note of the national human rights institutions established and operating under principles relating to the status of national institutions. The Paris Principles, for example, in particular in regard to quasi-judicial competence, may serve as effective means of addressing individual human rights violations. Now, there is a certain list of situations referred to the Human Rights Council. Now, under the complaint procedure since 2006/1 situation concerned by the Human Rights Commission. Now, we look into the year, the human rights session and outcome and history. The human rights situations in Cameroon, for example, in 2014 was the 27th session, that is A HRC 27-2 paragraph 129. The Human Rights Council decided to discontinue its consideration of human rights situations in Cameroon. Furthermore, it is to be also looked into the human rights situation which prevailed in Cameroon by the 2014 25th session A/HRC 25/2 paragraph 379. The Human Rights Council decided to keep under review the human rights situations in Cameroon until its 27th session. We look into the human rights situation in Eritrea in 2012 in the 21st session. The criteria which then looks into these situations, the learning outcomes would be that there is a group of treaties. Those treaties are basically a complaint procedure. The complaint procedure looks into complaints where there has been a gross violation of treaty and an alleged abuse of human rights. It tries to screen out the complaints. Those will be the learning outcomes. Now, in order to summarize, what is important is basically that all these treaties which are a part of the mechanism of the United Nations must be in compliance with the entire gamut of human rights violations in the selected parts of the world, such as Cameroon, Eritrea, and ensure that the complaint based mechanism is effective, so it ensures fundamental and human rights to people. The Commission reiterates its numerous calls upon the government of Eritrea without delay. A. It says to end its use of arbitrary detention of its citizens and to end the use of torture or other cruel, inhuman and degrading treatment or punishment, for example, to its citizens. B. To account for and release all political prisoners, including members of the G15 reform group as journalists. C. To account for those detained in the aftermath of the takeover on 21st January 2013 of the building housing the Ministry of Information and release them, or to ensure that they are given a free and fair trial with full respect for due process. D. To ensure free and fair access to an independent judicial system for those detained and to improve prison conditions, including by prohibiting the use of underground cells and shipping containers to hold prisoners, ending the use of secret detention centers and secret courts and the practice of incommunicado detention, allowing regular access to prisoners for relatives, legal advocates and other competent and legally authorized authorities and institutions, and to grant unhindered access to health and medical care. E. To put an end to the system of indefinite national service by demobilizing the national service conscripts who have completed their mandatory 8 months of service. This was announced by the government of Eritrea, and by effectively ending the practice of engaging these conscripts in forced labor after such a period. Furthermore, to provide for consensuous objection to military service and to end the compulsory practice of all children undertaking the final year of schooling in a military academy or a military training camp. F. To end the practice of forcing citizens to participate in the militia. G. To investigate promptly all allegations of extrajudicial killings, torture and other cruel, inhuman and degrading treatment or punishment, rape and sexual abuse within the national service, and to bring perpetrators to justice. H. To end the practice of shooting at Eritrean citizens attempting to cross the border. This is done basically to free Eritrea and to go to some other free country. I. To collaborate with human rights and humanitarian organizations, and to allow them to operate in Eritrea without fear or intimidation in order to facilitate the full implementation of the strategic partnership cooperative framework. From 2013 to 2016, signed by the Government of Eritrea and United Nations on 20 January 2013, as well as other human rights related projects. J, which is again important point, to respect everyone's right to freedom of expression and to freedom of thought, conscience and religion or belief, and the rights to freedom of peaceful assembly and association, and K, to enhance further the promotion and the protection of women's needs, rights, including or inclusive of taking additional measures to combat harmful practices such as child, early and forced marriage, and female genital mutilation or FMG, to implement recommendations made during its second universal periodic review, to report on progress made and to the cooperate fully with the Human Rights Council, as well as the universal periodic review during its third cycle. M, to end guilt by association policies that target family members of those who have evaded national service or seeks to flee Eritrea. N, to cooperate fully with the Office of the United Nations High Commissioner for Human Rights in accordance primarily with the international human rights obligations. Furthermore, inter alia allowing unhindered access to a further mission by the office as requested by the High Commissioner. The human rights treaty bodies and all mechanisms which are prevalent of the Human Rights Council, and to cooperate with all international and regional human rights mechanisms. O, to provide the office of the High Commissioner with all relevant information on the identity, safety, well-being and whereabouts of all persons who are detained and persons missing in action, including members of the G15 journalists. These members are those detained in the aftermath of a takeover on 21st January 2013 of the building housing the members of the Ministry of Information and the 19 Djiboutian combatants. P, to allow the creation of political parties and to hold free, fair and transparent elections, which is the basis of democracy at all levels in accordance with the international democratic standards. G, to account for the modalities and the progress of the expert group appointed to work on a constitution for Eritrea, while implementing at the same time looking into the constitution of 1997 in the meantime, and to govern in accordance with the principles of the rule of law and justice. Therefore, in summarize it, the Commission is trying its level best to bring about stability and preservation of human rights in Eritrea. Thank you.